Hi everyone, welcome to the second video for the week 8 lectures for administrative law. In this video, we'll be looking at two separate but related grounds of review relating to considerations that a decision maker makes that go into a decision. So the first is where a decision maker takes into account an irrelevant consideration in exercising a power. And the second part is where a decision maker fails to take into account a relevant consideration. So two sides of the same coin, but slightly different tests and slightly different ways of conceptualizing what's going on. So we do need to think of them as separate grounds of review. So let's talk about irrelevant considerations first. Section 5(2)(a) of the Administrative Decisions Judicial Review Act provides for a ground of review where a decision maker has taken into account an irrelevant consideration when making or exercising a power. So the first question we have to ask ourselves is, what is an irrelevant consideration? And luckily, Justice Stephen in Murphy Oars Inc. and the Commonwealth has given us a nice little statement. An irrelevant consideration includes all corrupt or entirely personal and whimsical considerations. And this is the key part: considerations which are unconnected with proper governmental administration. So this is quite a broad definition, but really what we're interested in is any consideration that is not connected with proper governmental administration. If it's not connected to the decision, if it's not connected to the kinds of things you would normally expect a decision maker to take into account, then it will be an irrelevant consideration. The second thing that's important to think about is that not all irrelevant considerations will vitiate or invalidate a decision. I really like this quote from Justice Burchett. It's true that a decision maker may not take account of an irrelevant consideration, but I think he may pick up a red herring, turn it over and examine it, and then put it down, so long as he does not allow it to affect his decision. So just because there's an irrelevant consideration in the mix doesn't necessarily mean that a decision will be invalid. And so the test is what is provided to us in Klein and Domas. Chief Justice Dixon, with whom Justices McTeon and Windeyer agreed, said that the irrelevant consideration has to be the dominating, actuating reason for the decision. So it's not enough to just say, well, there was an irrelevant consideration in the mix. You have to be able to show that that irrelevant consideration dominated the decision maker's decision or exercise of power. So the way that we do this is, for starters, looking at the reasons for decision. So again, that week 2 topic, really important here. But then trying to establish the way in which that irrelevant consideration has dominated everything else. So you could do that, for starters, if it's the only consideration that was taken into account. Of course, that's going to be the dominating factor. But the second way, which is a bit more common, is to try and establish that that irrelevant consideration has affected or impacted in some way on some of the relevant considerations. So, for example, in a finding of good character, something that's completely irrelevant to the decision, say, a person's skin color or their height or something, that the decision maker has taken into account that's clearly irrelevant to their character. If you can show that that has then led into or affected the way the decision maker has reviewed relevant considerations, such as criminal history or references from personal references or something like that, then you could establish that the irrelevant consideration has dominated the other reasons for the decision. The other way that you can establish it is within the reasons for decision, if the decision maker themselves actually says, these are the facts on which I've made this decision, and then these are my reasons, and the irrelevant consideration is really prominent in those reasons. So there's a few possible avenues, but what's really important is that we are looking at the irrelevant consideration being the dominating reason. Of course, the flip side when this, goes to judicial review is that the decision maker will try and downplay the effect of the irrelevant consideration, and they'll try and upplay the importance of the relevant considerations that they took into account. So there's, of course, there's going to be pushback from the decision maker there. So having a really strong foundation on which to argue this was a dominating factor is absolutely critical. The second ground of review for this video is failing to consider a relevant matter, which is provided for under section 5.2b. This will only apply where a statute expressly or impliedly provides that a particular consideration has to be taken into account. The tricky distinction being if the requirement is expressly provided for, then it might actually be a jurisdictional error. So you remember in week 7, we talked about jurisdictional and non-jurisdictional facts. If a relevant matter is expressly provided for, so, a decision maker has to take into account something in order to make their decision, then it might actually be that that something is a jurisdictional fact. And if that hasn't been established, or if that hasn't been considered, then the decision maker actually has no authority to make the decision. So you can see these two grounds of review potentially overlapping a little bit. But if the requirement is not expressly provided for in the Act, then we have to read the Act as a whole to see if it is implied that the decision maker should take that matter into account. And so Justice Mason in Minister for Aboriginal Affairs and Pecco Wallsend said that if relevant factors are not expressly stated, they must be determined by implication from the subject matter, scope, and purpose of the Act. So reading the Act as a whole, what are the kinds of things that a decision maker should be looking at or thinking about before they can make that decision? Now, it's worth talking in a little bit more detail about Pecco Wallsend as a case. And I'm going to give you, it's a fairly complicated case, and I'm going to give you more detail than you necessarily require, just so that you understand all the background issues that went into the decision. But I'll still try and keep it as simple and brief as possible. So under the Act, the Minister for Aboriginal Affairs could make a grant of land to Indigenous people who were traditional owners of that land. The Minister would do so on the recommendation of a commissioner. So the way the process worked is that a Indigenous group or communities would make an application to the commissioner to say, we are the traditional owners of this land and we want to be recognised as such. The commissioner then had to have a public inquiry to go into, to assess the merits of the claim, any other competing interests, the effect of granting the claim, all that sort of stuff. The commissioner would then make a recommendation to the minister, and the minister was the final decision maker. In this case, there was a parcel of land over which a group of Indigenous people wanted to make one of these claims. Sort of competing against that was the fact that within part of the land was a valuable uranium deposit. And so Pecco Wallsend were sort of a prospecting company that identified there's a bunch of uranium here that we would very much like to access and mine. And the conflict arose because granting traditional custodianship over that land would have made it really expensive for Pecco Wallsend to then mine that uranium. The commissioner held an inquiry, as they were required to under the Act. Pecco Wallsend made a submission to that inquiry saying, look, there's this really valuable uranium deposit here. And one of the things that the Act directed the Commissioner to take into consideration was any potential detrimental effect that granting the land to the Indigenous group would have on any persons or communities, including other Indigenous communities. Because sort of Peko Wallsend, the exact location of the uranium was a bit of a trade secret, they didn't submit to the inquiry the exact location of where the uranium was. They said it's in this general area, and they actually sort of pointed to a part which was a bit further away than where it actually was, which was a silly mistake on their part, because the Commissioner, in recommending that the land be granted, said they sort of partialed out the whole area and said, these are parts that we can absolutely happily grant to the land trust. There's no detrimental effects. That's fine. We should go ahead. The Commissioner made the recommendation that those should be granted to the Indigenous Land Trust. No problems. The Commissioner then also identified, these are some parts where there's uranium and there's competing interests. We need to balance this a bit more closely. We need to do some further work, and we need to have a bit more of a think about this. The difficulty being that the really valuable uranium deposits were in the bit that was granted straight to the Land Trust, no problems, because of the evidence that Peko Wallsend had presented. Then there was a change of government. New minister comes in, and they're briefed but not fully, because there's a lot to take in when you're a new minister. And so they were just given a list of land claims that were yet to be processed, and the minister went through and just went, yep, tick, 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 we'll grant all of those, no problems. And so the portion of the land over which there was still a dispute was also granted, no problems. The argument then on Peko Wallsend's part was that the minister hadn't taken a relevant consideration into account in approving the grant of land to the Indigenous Land Trust. The argument was there was this controversy over the uranium deposits, which was relevant because it was going to potentially detriment people in the community, i.e. their mining interests. And the minister didn't take that into account when approving the grant of land to the Indigenous Land Trust. And in that case, the court said, yes, this was a relevant consideration, and the decision maker, the minister, failed to take that into account in making their decision. It was expressly provided for under the Act that the Commissioner would have to consider detrimental effects, and then by extension, it was incumbent on the minister to take that into consideration as well in making that final grant. And because the minister didn't do that, the decision was invalid. They'd failed to take into account the potential detrimental effect of a grant of land on the community as a whole, and that invalidated the whole decision. So like I said, a bit of a complex case, but at the end of the day, what it came down to was that the minister hadn't taken into account the relevant consideration, which was the effect of this decision on Peko Wallsend's commercial interests. We'll wrap up this topic by going through some cautions that Justice Mason identified in Peko Wallsend in relation to failing to consider a relevant matter. And in particular, Justice Mason was very keen to emphasise the limited role of the court in judicial review. And in particular, Justice Mason was talking about it's not for the court to substitute its own decisions. You will remember we've talked about the distinction between merits review and judicial review to say that it's not up to the court and judicial review to give its own decision, its own version of what the decision should have been. It's just up to them to decide whether or not the proper judicial or the proper process has been followed. What that means in relation to failing to consider a relevant matter is that the court can identify whether a relevant matter has been considered or not, or whether it's been failed to be considered. But usually it's going to be for the decision maker to determine the appropriate weight to give certain factors. That's not for the court to say. So a decision maker might consider a relevant matter, but then also decide that it shouldn't be given much weight in relation to other factors. That's not something that a court should generally be touching. It should just be looking at, was it considered at all, yes or no? So that's something to keep in mind. The other thing that is worth keeping in mind is the blurred line between failing to consider a relevant matter and unreasonableness, which we'll look at in week 10. So if something is really, really obvious that a decision maker should have looked at, if they don't look at it, then arguably the decision is so unreasonable that no reasonable decision maker would have made that decision, which is the test of unreasonableness that we'll look at in week 10. So again, we've got another potential overlap between topics here, where failing to take into account a relevant matter might just be so grossly incompetent that the decision is also unreasonable. So be alert to that in a couple of weeks' time. We will leave it there for now, though. Thanks for watching these videos. We'll come back in week 9 to talk about natural justice and procedural fairness. So we'll see you then. Thanks very much.